We have major breaking news out of the District of Hawaii. Barack Obama appointed Judge Derek Watson has found that short barrel rifles and machine guns are not protected arms under the Second Amendment, notwithstanding the fact that the text of the Second Amendment refers to arms, and the Supreme Court has defined arms for the Second Amendment purposes as anything that can be used offensively or defensively. And yet somehow neither machine guns nor short barrel rifles can be used offensively or defensively, apparently according to the logic of Judge Derek Watson, District Court, Federal District Court in Hawaii. Let's break down all the mistakes Judge Watson made when we come back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Attacks Teach Americans About the Right to Bear Arms. We must always learn from the mistakes of others. And for those of you who are going to be at the Gun Rights Policy Conference sponsored by the Second Amendment Foundation out there in San Diego in a couple weeks, I will be there as well, giving a couple speeches and doing a book signing. So make sure you catch up with me in San Diego. Looking forward to the event by the Second Amendment Foundation in just a few weeks. All right, folks. Craziness out of the United States District Court for the District of Hawaii. A criminal case involving Christopher Chang, who is alleged in an indictment to have unlawfully possessed a machine gun as well as a short barrel rifle. Mr. Chang filed a motion to dismiss this case in the case of United States versus Chang, claiming that this indictment violated his right to keep and bear arms under the Second Amendment. He also claimed that the federal statute violated the Commerce Clause, and that Congress does not have the legal authority under Article 1 of the United States Constitution to ban the possession of such weapons. There is nothing that touches fingers with any of the enumerated powers of Article 1 by Congress, including but not limited to the power to regulate interstate commerce. Now, Judge Derek Watson, who is an appointee to the federal bench by President Barack Obama, no shock here, found that this motion to dismiss should be denied, and there was no violation of the Second Amendment. Not a shock there, because you're dealing with a judge in Hawaii, and they're all fundamentally terrible on the Second Amendment and fundamentally terrible on the Bill of Rights. I guess that's part of the problem when you live on a set of islands that recently became part of the United States, and you are a monarchy. Not that long ago, perhaps that monarchical blood has not really left the island, and that sort of atmosphere and culture hasn't really left, and you like the notion of king being the boss and the rest of those Hawaiians are subjects and serfs. Nevertheless, we don't need to speculate about the culture of Hawaii right now, other than, of course, it's terrible on the right to keep and bear arms and the Bill of Rights generally. So, but let's laser focus in on the logic of Judge Watson just to show how terrible it is and inconsistent. And the reason why it's terrible is it's because entirely inconsistent with black and white clear precedent by none other than the United States Supreme Court Second Amendment cases. So to begin with, let's start with what Judge Watson says. The first thing is he starts off kind of okay. He starts off saying that, well, under Bruin, which is really Heller and Bruin, he says the way you work is you start with whether or not a modern-day gun control law or the proposed conduct or conduct of the Second Amendment proponent, does it get implicated by the text of the Second Amendment? The text of the Second Amendment, of course, says the right of the people to keep and bear arms shall not be infringed. Well, obviously, if you have a restriction that says that you cannot possess a short barrel rifle, which is a firearm, or a machine gun, which is a firearm, and obviously firearms are arms, we know that from, among other things, Heller, that says that, firearms are arms. Why? Because arms, under the text of the Second Amendment, is anything that can be used offensively or defensively, including, but not limited to, firearms. That's Heller. So, of course, Judge Watson starts off sort of okay by saying that, well, once the text is implicated of the Second Amendment by what the plaintiff, or in this case, the criminal defendant, wanted to do, i.e. possess firearms, then the burden shifts to the government because that conduct is presumptively constitutional. And because it's presumptively constitutional, once it shifts to the government has the burden to come forth with, of course, showing a long-standing tradition of firearms regulation analogous to what the modern-day gun control law they're trying to uphold is. and stands for, right? Okay, so that part is okay. But then Judge Watson goes right off the rails, because the next thing you know is he skips over the textual analysis. Now, he pretends to do a textual analysis, the textual threshold authority analysis, I should say. And what he basically says, well, there's this notion of dangerous and unusual firearms, and by extension, there's this notion that if an arm is in common use by Americans for self-defense purposes, is what he says. It's not, obviously that's too narrow, but that's what he says. It's protected. But here he goes on to say that the short barrel rifle and ultimately the machine gun, they're not in common use by Americans for self-defense or for lawful purposes or anything like that. And as a consequence, the text is not implicated. Hear what I just said? This is very important to understand what I'm about to say, because this is a major screw up by this judge, I'm sure at the urging of Merrick Garland and Kamala Harris's Department of Justice. What this judge did is he pretended to be doing the textual analysis correctly of the Second Amendment by reading the text of the Second Amendment. And then what he does is he does a sleight of hand here, and he conflates the historical part of the test, where the burden is on the government to show a historical tradition. He conflates that with the text and says that the Second Amendment proponent, in this case the criminal defendant, did not satisfy the text. That's clearly hooey. Because all he needed to do to satisfy the text is to show that to show that a short barrel rifle and a machine gun are firearms and thus are arms. That's it. The text is satisfied and the burden shifts to the government. And what is the burden shift to the government when you're dealing with an arms ban case, which this basically is? The burden is on the government to show a historical tradition. But when you're dealing with an arms ban case, guess what? It's a lot easier. Why is that? Because the historical analysis of looking for a long-standing tradition of firearms regulation when it comes to banning a type of arm has already been performed by the U.S. Supreme Court in Heller. They already looked at the historical tradition of firearms regulation as it relates to arms bans, and they said that if something is in common use by Americans for lawful purposes, it cannot be banned. Period, full stop. That's it. It's sufficient for the Second Amendment proponent, in this case a criminal defendant, to win. And here's the other critical thing that Judge Watkins screwed up here, okay? He screwed up because who bears the burden? At the historical level of the text first, burden shifts to the government. The presumption is the law is unconstitutional. And the burden shifts to the government to show the historical tradition. Who bears the burden? The answer is the government. So what does Judge Watson do here? Guess what he does? He places the burden of proof on the criminal defendant, asserting the Second Amendment right, to show that these arms are in common use by Americans. But that is why Judge Watson elevated and conflated the history portion of the test with the text, because at the textual level, allegedly or arguably, the burden is more or equal, or at least arguably on the Second Amendment proponent. It hasn't yet shifted to the government. So by saying that the in common use test is part of the textual analysis, and therefore he says the burden is not yet shifted to the government to show that something is not in common use. Do you hear what I just said? The burden is on the government in the in common use test to show that something is not in common use. Why? Because the in common use test arises from the historical tradition of firearms regulation. And because you're dealing with historical laws, historical tradition, you're in the history part of the text first and history part of the analysis. And at the historical level of the analysis under Heller and Bruin, the burden is on the government, which means that Judge Watson here, Derek Watson, should have required the government to show that short barrel rifles and machine guns are not in common use. Do you see the difference? What he did here, though, is he basically said that I, Judge Watson here, do not believe that the Second Amendment proponent, the criminal defendant here, Mr. Chen, has demonstrated that these arms are in common use. But that's wrong, because the question is not that. The question is, did the government show that these weapons are not in common use by Americans for lawful purposes. And if you look at that, the data that was provided in this opinion, the hundreds of thousands of short barrel rifles, I mean, he then goes on to say there's 700,000 machine guns. The right answer is civilian-owned machine guns that were in existence in 1986 when the Hughes Amendment went into effect. It's somewhere in the order of magnitude of about 170,000. Okay? But either way, the burden should have been on the government to show they're not in common use. But Judge Watson here got it backwards. And then he goes on to make another terrible mistake. Because he says that to figure out if an arm is in common use or not in common use, you then look at the percentage of guns of a particular type of gun, and you compare it to the overall number of guns in the United States. And he says, as a consequence, if you look at the number of short barrel rifles and the number of machine guns, and you compare that to the total denominator, if you will, the denominator and the fraction of all the firearms in the United States, that fraction, meaning the number of short barrel rifles and or the number of machine guns divided by the total number of firearms in America, it's a very small percentage. But this is just simply hooey. This is made up BS. And we know it's made up BS because if you look at the Heller case, where they're talking about handguns, there's no discussion of the percentage of handguns in the United States versus the number of firearms in the United States. There's no discussion of a numerator or a denominator. There's no discussion of proportionality or a fraction of anything. They simply say that Americans clearly buy lots of handguns and own lots of handguns, and that is more than enough to show they're in common use, and they cannot be banned. Period, full stop. There's none of this games and moving and, let's look at the bottom of it and let's look at the top of it, let's look at the fraction. No, none of that hooey. The government bears the burden to show that a particular type of firearm is not in common use. They simply cannot do it when you're dealing with short barrel rifles. As to machine guns, that's a debatable I think that's more of a debatable proposition, which we don't need to get into for the purposes of this discussion. But the bottom line is the short barrel rifle, to me, is clearly a protected arm. Obviously, textually it is. Chan claims there are 532,725,000 short barrel rifles registered and lawfully possessed in the United States. Again, that's great that Mr. Chan put that information forward based presumably on ATF documentation. I'm sure that's public. You can find that number. But it doesn't actually matter because, again, the burden of proof is on the government to show they're not in common use, and the government cannot do that. And, of course, the other mistake that Judge Watson made was trying to conflate the notion of in common use with trying to say that you have to show that a particular arm is used for self-defense. And, of course, we know that all you have to show based on Heller is simply possession of the firearm, because possessing the firearm is using the firearm, right? It's like a fire extinguisher. It's like life insurance policy. It's like a homeowner's policy. Merely owning this means you're using it. Merely owning the gun means you're using the gun for whatever the reason, including maybe you like to collect, maybe you're using it for self-defense. Whatever the purpose is, you're allowed to own a gun, and that's using the gun is to own the gun. Right? You don't have to touch the gun or shoot the gun or anything like that. And that's exactly what Heller said, because there was no discussion of anyone pulling the trigger of a handgun or using the handgun in self-defense or anything like that in terms of trying to, add up the data to show the number of times it was used in any particular way. The bottom line is that handguns were ubiquitously owned. Everyone had them, and that was enough to show you can't ban them. Period, full stop. That was Heller. But of course, when you're dealing with an Obama appointee judge as a general matter, to me it's analogous to the moderators from ABC News in the Harris-Trump first debate this year, where the moderators are in the tank, in my opinion, for Kamala Harris. Now, they may not come out and say that, but the way they conduct themselves in fact-checking Trump, even though they got a lot of that wrong, and not fact-checking Harris, it's kind of how a lot of these federal district court judges that hate guns behave. They sort of create the impression that they actually are trying to follow the rules, that they're trying to follow the Constitution. But if you actually look at the way they do nuanced analysis and sort of tilt the game in a particular way, you can see their bias. And this is an example, of my view, that Judge Watson is looking for a way to make sure that the anti-gunners in America win the case. No shock there. That's exactly what I would expect out of Hawaii. A beautiful place physically, but when it comes to the Bill of Rights, not so sure their culture is up to snuff. I'll let you guys debate this in the comments below. All right, the last point I want to make is there's a Commerce Clause argument. All I want to mention to you, if you're going to make the argument about Commerce Clause involving an NFA item, you have to always cite up front and center, in my opinion. This is a little tricky because it's the U.S. Court of Appeals for the Third Circuit out of New Jersey, Pennsylvania, and Delaware. The dissent by now Justice, but then Judge Samuel Alito, that explains that the Hughes Amendment enacted by Congress in 1986 lacked a interstate commerce predicate or hook. So anyone who wants to argue a Commerce Clause argument involving firearms, to me, you should usually start your analysis and look very carefully at the theory and arguments of then Judge, now Justice Alito, in the Rybar case, United States versus Rybar. I want to say that was I think that's a 1996 case or something like that. I can't remember the exact date, but you can certainly find that case of Rybar out there. And I would look very carefully at that. That's how I would frame it up. But needless to say here, basically Judge Watson says that he is bound by Ninth Circuit precedent, that these laws are constitutional under Article 1. But I have to say it's not clear to me how banning an ordinary American from possessing a short barrel rifle or banning an ordinary American from possession of a machine gun in and of itself somehow has an interstate commerce hook. But again, that's a debate for another day. All right, to summarize, the criminal case against Mr. Chan will continue. The motion to dismiss on the Commerce Clause and on the Second Amendment was all denied by Judge Watson. So we'll kind of keep you apprised as to this case moves forward, see what happens next. But in the meantime, make sure you follow me on X. A lot more political information on X at 4Boxes Diner. And don't forget to subscribe and like this video. We're trying to build our numbers here. The numbers are going very slow. I'm not quite sure why that is. I have some ideas, but I really would like your support, you and your friends in the Second Amendment community, to keep increasing the number of subscribers. We're very far behind a lot of other Second Amendment people. And I know we're newer, but I would appreciate your support going forward. All right, folks, so there you have it. And we will talk to you again soon, very, very soon, I hope, here at the 4Boxes Diner.
Orders up. Table 2A.